Get ready for dictation at the speed of 100 words per minute. Start. The High Court is entitled to satisfy itself as to the correctness or legality or propriety of any decision or order impugned before it has indicated above full stop. However, to satisfy itself to the regularity, correctness, legality, or propriety of the impugned decision or the order. Full stop. The High Court shall not exercise its power as an appellate power to reappreciate or reassess the evidence for coming to a different finding on facts. Full stop. Revisional power is not and cannot be equated with the power of reconsideration of all questions of fact as a court of first appeal. Full stop. Where the High Court is required to be satisfied that the decision is according to law, comma, it may examine whether the order impugned before it suffers from procedural illegality or irregularity. Full stop. We thus approve the view of this court in Rukmani as noted by us. Full stop. The decision of this court in Ram Das must be read as explained above. Full stop. The reference is answered accordingly. The full stop. The civil appeals and the special leave petitions shall now be posted for the regular benches for decision in light of the above. Full stop. Paragraph change. In the facts of the present case, when the appellate relied upon the commissioner's report stating that there are 36 rooms in the building and that the majority of the rooms are let out, showing that some of the rooms in the occupation of the landlord are lying vacant, comma, it cannot be said that there is any perversity in this finding of fact. Full stop. Even assuming that the High Court is correct in its construction of Section 11 of the Kerala Rent Control Act, stating that vacant rooms in other buildings cannot be looked at, this finding of fact of the appellate authority puts paid to any bona fide requirement of additional accommodation of the landlord in the facts of the present case. Full stop. The reliance upon the building tax assessment register by the appellate authority showing that some of the rooms belonging to the landlords were lying vacant again is a finding of fact which cannot be interfered with in the manner done by the High Court. Full stop. Further, the finding had that a room leased by the mother-in-law of the tenant in another building is not in the tenant's possessions only because he had his mother-in-law's permission to store goods on a temporary basis would also show that he cannot be considered to be in possession of the said room. Full stop. Paragraph change. Interfering with this finding of fact, again without any perversity or misappreciation of evidence by the appellate authority, would clearly be outside the High Court's ken in revisional jurisdiction. Full stop. Equally, the finding of comparative hardship, which is a finding of fact not otherwise found to be perverse, cannot be upset in the manner done in the present case by the High Court. Full stop. Learned counsel for the respondent, however, relied upon the judgment of this court in Badri Narayan. This was a case which arose under the Bombay Rents, Hotel and Lodging Houses Rates Control Act 1947, Section 13(2) of which states as no decree for eviction shall be passed on the ground specified in clause G of subsection if the court is dissatisfied that having regard to all the circumstances of the case, including the question whether other reasonable accommodation is available for the landlord or the tenant, greater hardship would be caused by passing the decree than by refusing to pass it. Full stop. Where the court is satisfied that no hardship would be caused either to the tenant or to the landlord by passing the decree in respect of a part of the premises, the court shall pass the decree in respect of such part only. Full stop. Paragraph change. The finding of fact arrived at by the appellate authority and sustained by the High Court as to bona fide requirement of the landlord in that case was upheld by the Supreme Court. Full stop. The only question that the Supreme Court was called upon to decide is the exercise of discretion under Section 13(2) of the Bombay Rent Act so far as partial eviction is concerned. Full stop. Paragraph 10, strongly relied upon by learned counsel for the respondent, is in the context of a partial eviction being order, in which this court stated it is expected of the parties to raise necessary pleadings and the courts to frame an issue based on the pleadings so as to enable parties to adduce evidence and bring on record such relevant material as would enable the court forming an opinion on the issue as to comparative hardship and consistently with such finding whether a partial eviction would meet the ends of justice. Full stop. Even if no issue has been framed, the court may discharge its duty by taking into consideration such material as may be available on record. Full stop. Paragraph 13 was then relied upon, which dealt with an English judgment in Piper v. Harvey, in which it was found on the evidence adduced in that case that the comparative hardship issue would have to be decided against the tenant. After going into the facts, the present petition has been filed under Section 9 of the Arbitration and Conciliation of Act 1996 with the prayers. In view of the above facts and circumstances, it is most humbly prayed that this Honorable Court may kindly be pleased to grant the following interim measures of protection, namely 1. Pass an order restraining the respondents, his employees, agents, servant, or anyone acting on his behalf and instruction from illegally and forcibly disposing the petitioner from the Hotel Regenta LP Villas situated at Chakrata, Dehradun, and from interfering with the petitioner's operation and management of the said hotel and from preventing or obstructing the petitioner's operations thereof and further from entering into any agreement or arrangement etc. with any third party in regard to the possession, operations and management of the aforesaid hotel for the commencement of or during the pendency of the arbitration proceedings that may commence in due course. Full stop. 2. Pass and interim ex parte orders in terms of prayers herein above. 3. Pass such other relief as the Honorable Court deem fit in the interest of justice and equity 4 pass an order granting costs in favor of the petitioner and against the respondent in respect of the present proceedings. Full stop.